Often in a probate case, there's going to be a piece of real estate, and a lot of times you, the heirs, the beneficiaries, you're going to want to sell the property. So do you have to get this sale approved by the court? Really depends on what type of property is. Here in Florida, we have what's called homestead property, which is your primary residence. It's not a secondary home. It's not a rental home. It's where you live the majority of your year of the year, and you get to call it your homestead. Most of the time, if that's the property that you're trying to sell, you don't have to get court approval. What we're going to do is we're going to ask the court to transfer the property to the new heir's name. So if that's you, we're going to ask the court to transfer to your name. That's the new deed. We record that you own the property, and then when you go to sell it, you sell it as any other piece of real estate. You and whoever the other owners are going to sign the closing documents with the title company, the title attorney, and that's it. If, however, it's a secondary home, so this is not a primary residence, maybe mom and dad lived in New York most of the time, but they had a second home, in Florida, or an investment property, or it's a rental property or something like that. If that's the case, we're not going to be able to say that that's the homestead. And if you all want to sell it in probate, we can do that. We can actually ask the court to approve the sale, sell the property, all the proceeds gets put into a restricted account or similar to an escrow account until the end of the probate, and then the money's distributed, between all the beneficiaries. There's a lot of benefits to that because if you have 10 siblings who are all inheriting the property, you might not want to go through the probate process and just have 10 people all on title. If you're the personal representative or the executor, it might make sense for you to sell the property in probate, and you're not going to need all other 9 people signing off on title. You as the executor are going to be able to sell it. Now, what you're going to have to do though is you're going to have to notify everybody. You're going to have to tell the judge. The judge is likely going to look at the contract. The judge wants to make sure that you're not, selling this property super cheap to yourself or to a friend or something like that. They want to make sure that you're getting fair market value to it. So there will be a little bit of court oversight in that. But a lot of times, again, if you all are not trying to keep it and you don't want to have a bunch of different people on title, we're probably going to suggest that we sell the property in probate. So you're not going to have to do that all the time. Again, if it's a homestead property, we probably can't actually do that. But if it's a secondary home, we might go ahead and try to sell it in probate. In that case, the court's going to want to review everything.